This is the Pierce County Law Libraries. This month of March will be Real Property Month. So Mark is going to be here today talking about ejectment. If you have any questions, please put it in the Q&A and I'll make sure that those questions are addressed at the time they're asked. All right, and we are recording. So if you have any concerns about that, please get a hold of me and I sure appreciate it. Otherwise, I will be here working in the background and I'm looking for Joyce Healy. Thanks, Mark. We really appreciate it.
Okay, thank you very much, Amy. So I assume that we are ready to start, so I'll begin. A little bit about myself. I'm a practicing attorney. I work out of my office in Gig Harbor, primarily practice in the area of family law. I am a family law mediator, although a lot of my mediations do involve other sorts of disputes, real property disputes, TEDRA disputes, quiet title, and the like. Also serve as a Pierce County Pro Tem Court Commissioner. And over the years, I've practiced in civil litigation and spent my early career as a prosecutor, which, as I'm sure many of you know, a great way to get your feet wet and get yourself in the courtroom. As we're going along today, I really do encourage everyone to chime in with comments, questions, thoughts, observations. By no means do I pretend to be an expert in this field of law. Much of what we're going to discuss today comes, I guess, from my experience in the cases that I've done, but also, quite frankly, from the Washington practice, which is an excellent resource for sort of all things Washington law, but certainly the real property section of Washington practice is particularly helpful for a lot of these doctrinal things that maybe we don't deal with all the time, or maybe haven't even dealt with since law school. So with that, let's get going. Here's the big picture. Let's talk about what ejection is not. And this is so commonly conflated both by attorneys, lay people, and the bench. But ejection is not eviction. Ejection or ejectment and quiet title flow from the common law. They are now codified in Washington state at RCW chapter 7.28. But they are fundamentally different in every way from the statutory unlawful detainer provisions and the Uniform Landlord Tenant Act. And then in the other similar acts, the Mobile Home Act, and then the acts that deal with commercial leases. The remedies, as we'll get into in a little bit, are substantially different. The big deal, though, is procedurally. We'll talk more about procedure for seeking quiet title or ejectment. But as many of you know, under the unlawful detainer statutes, evictions are summary procedures, and there are very specific procedural steps that must be taken, which include very specific notices, notice periods, and limits on what a court can and cannot do in summary proceedings. Critically, unlawful detainer actions flow from the existence of a lease. And often ejectment is called into play because we don't have a lease and we have someone in real property who is unlawfully occupying it. And there isn't any other way to get them out other than this sort of old school legal action. I think 9 times out of 10, if there is a lease involved, it is far preferable to go down the road of unlawful detainer because, again, it is a summary proceeding. It is far quicker. It is far easier. It is far cheaper. But again, that is not going to fit every circumstance. So we need to know what else we can do when unlawful detainer isn't going to fit the bill. This next slide is just, again, sort of an overview. In the big picture, ejectment is focused on ownership, because the ejectment statute is coexistent with the quiet title statute. In fact, they are in the same sentence in RCW 728010. We're really focused on superior title, ownership of property, who ultimately has the right to own something. Unlawful detainer focuses more on possession. Do we have a tenant or other occupier that by way of a lease or some other contract has rights to a unit but is failing to perform their obligations under that agreement? So two conceptually very different applications and different resolutions. Ejectment and quiet title will result in a declaration confirming who owns something, who has superior title, who ultimately has the right to convey, possess, or otherwise dispose of property. And again, what you're going to get out of an unlawful detainer action is possession. Somebody's in there who shouldn't be. Through unlawful detainer, you can simply get them out, but that will not resolve any disputes about title. Again, encourage everybody or anyone to jump in at any point. And I'll ask anybody, have any thoughts, comments, questions at this point?
Just to let everyone know, I have unmuted everybody, so feel free to pop in as you need to.
Okay, before we get into sort of an overview of ejectment and quiet title, there is another action out there that deals with possession of property. And I don't have a slide for it, and it's not something that directly pertains here, but I think it is worth mentioning just so that we all know that there's another tool in the toolbox that may fit in certain circumstances. And that is RCW 9A 52105, which is the removal of unauthorized persons statute. So Title 9A 52 is the criminal trespass section, the same section that gives us the burglary and criminal trespass statutes. And near the end of that title, or excuse me, the end of that chapter, we see this removal of unauthorized persons. And what that allows someone to do is invoke law enforcement to remove someone from a property. It requires the submission of a very specific statutory declaration. The form of the declaration is found at 9A 52115. And then by this statute, if you check all the boxes and law enforcement deems the statute applicable, law enforcement can remove persons from a residential property. This doesn't apply to commercial property. And law enforcement has the discretion to either arrest or not arrest that person. If they have probable cause that the crime of criminal trespass or perhaps the crime of burglary is being committed, they certainly could and should arrest. But again, it is ultimately discretionary with the specific officer who's dealing with it. They can also just simply order the person to leave, order them to remain off the premise. A lot of times what we see is either before law enforcement is involved or after law enforcement is involved, some sort of formal written admonishment is served upon the individual. And I think it is a good practice if you are potentially going down this road to go ahead and serve a statutory admonishment, letting the person know that if you do not comply with a request to vacate or leave, that law enforcement will be engaged. The statute has some due process protections. Officers are required to give an occupant a reasonable opportunity to provide evidence that they are tenants, that somehow they have a right to be there. Perhaps there's a lease, or perhaps they're guests or invitees, and that law enforcement does not indeed have the authorization to remove them. The statute instructs officers to consider such evidence before requiring the parties to leave, or certainly arresting them. The declaration that I referenced, again, which would be found at 9A 52115, requires the declarant or the property owner to confirm under penalty of perjury that they are indeed the owner or the agent of the owner. These people do not have a right to be there and that their presence is unlawful. They're not authorized to remain. They are not current or former tenants, so that there's not any sort of holdover or lease-related arguments. That they've previously made a demand to leave that was refused. So that goes back to what I said a moment ago about providing some formal written admonishment. As we lawyers know, put it in writing. And this is certainly one of those cases. It's going to be easier for a deputy or an officer to know with certainty that you've made a formal request that they leave if they see this written admonishment. There's a couple other requirements under the statute. The owner must confirm that the property is not abandoned, the property is not open to the public, and that the owner understands that if they are asking for this removal unlawfully, they may face civil and criminal liability. And then there's also a law enforcement indemnity clause within the statutory declaration.
Good
Big
afternoon,
picture
Mark.
with the stat. Yes.
I'm just curious because I have attempted this on several occasions. I'm wondering if anybody, yourself or anybody in the audience, has had any success at getting law enforcement to actually execute on this. I have been declined on multiple occasions, both by the Pierce County Sheriff and TPD, to the point where just out of curiosity, I have spoken to Tacoma's attorney, city attorney, and to the sheriff's attorney just to get their take on it. And all I got was, we're not going to enforce this. And so I'm just wondering all these years later if anybody else has had a different result.
I guess I could chime in. I just got denied this earlier this week in Federal Way. They told me there was credible belief that they had received permission roughly a year ago to stay there. The police didn't give me any documentation or any, declaration of a statement made to that effect, but they essentially just said, "Oh, well, we believed him to be credible, so that was our due diligence, and you have to go through the ejectment process." So I got a similar reaction, it sounds like.
Yeah, I think 9 times out of 10, they'll defer. They'll say this is a civil matter and they won't get involved.
That's been my impression for a really long time too, that they have no particular interest in diving headlong into what is, at least to the law enforcement side, um, a problem where they could expose themselves to liability, even when the statute says no, the sheriff isn't liable for this. And that instead they're going to sit back and wait for an order that's entered after an opportunity for notice and a hearing, and that I have never seen a sheriff actually take advantage of this particular RCW, not once.
Hmm. And I'll chime in too. My experience has been similar, I guess with one caveat. When I was a prosecutor, I do recall circumstances like this being referred as potential misdemeanors. And so what law enforcement is doing in that case is, again, sort of kicking the can down the road or passing the buck. In the circumstances that I can remember, I guess there'd been enough of an issue raised for a long enough period of time that an officer or a deputy or a supervisor said, hey, well, we got to do something. Something doesn't mean we're going to go march into this house and yard this person out, but hey, let's kick this up to the city's attorney's office or the prosecutor's office and make it, their decision. And that may well be what continues to occur in situations today. But thank you for those comments. I think it is interesting to hear everybody having such very, very similar experiences with the statute. I hadn't even really intended to raise it because it's not directly related to ejectment or quiet title actions. But again, it's adjacent, so I thought it was worth the discussion. So then let's talk about ejectment and quiet title. As I said a few minutes ago, these are common law doctrines that have been codified in Washington state. Both ejectment and quiet title as causes of action come from the first sentence in RCW 728010. And my first go around with this was a bit awkward. It was somewhat confusing and even challenging to sort of parse out exactly what the statute authorized, if there were other statutes that gave us more information, or whether we were sort of left with just kind of figuring this out. It's also interesting that this 728010 is found within a chapter that contains a lot of other real property related remedies, adverse possession being one. And it's sort of just kind of part of this big mismatch, which I found somewhat surprising because these two doctrines are incredibly common, incredibly important, useful, and often employed in a lot of different circumstances. So the fact that statutorily it's just sort of this one little teeny tiny part of the code was somewhat surprising to me. 728010, as I said, it combines these two doctrines into a single provision, and it uses fairly broad language. It says that one may recover possession, or one may quiet or remove a cloud on title. Again, I think that this goes back to its common law roots and sort of harkens back to doctrines such as replevin and certainly the mechanisms for quieting title or removing a cloud from title. Replevin is another interesting, not directly related provision that deals with possession of not real property, but personal property. Similarly comes from the common law and is now codified in the revised code of Washington. Because quiet title and ejectment and adverse possession and several other real property related doctrines are all found in chapter 728, it's not uncommon that within a single lawsuit or within a single action, one would plead several different causes of action that all sort of flow right out of the same statute or right out of the same chapter. And as I think we'll get into pleading in a little bit here, I think courts are used to that. They're used to seeing alternative claims, whether we're going to prevail on an ejectment, or if we need to quiet title first, or if it is neither of those, and perhaps we've got a boundary line issue and it's an adverse possession. But it's not uncommon to see some or all of these different causes of action or legal theories pled within the same lawsuit.
Mark, may I interject for a
Yeah.
moment? E. Powell made a comment that said it was codified in the very first territorial legislature in 1854.
Okay. Thank you.
I've I've been wrapping up an appeal at Division One, and at this point all the briefs are in, and they said they were going to decide it without oral argument on February 27th. So of course I've been checking on it, and I don't have a decision yet. I don't know what's going to happen. They said they were going to do it without oral argument, and that can cut both ways. Um,
Mm.
yeah, I just don't know what they're going to do. But I did a huge deep dive on the history of RCW 728
Mm.
within the last year. It's been quite the adventure. So I've,
Can you share more with us? Admittedly, my deep dive, as I think I admitted early on, is pretty much limited to what Professor Weaver told me in law school,
I
and what
believe
he
you.
later put in the Washington practice editions.
Right. Well, that's kind of the general idea as to what is out there is that, oh, this was common law. No, actually it's not. Well, it was just very basic. And where unlawful detainer practitioners tend to focus on is section 728. I think it's 250. And that says a landlord may, use this so long as the tenant doesn't run into court and pay what's due and follow the other obligations under the lease, and in which case the tenant is not unlawfully, well, should not be ejected from the property. So I'm dropping in the case number at Division One, and
Hmm.
my argument there is on the appropriateness of an ejectment action in a residential tenancy. And
Oh,
how they decided to approach that, because I personally think that's some nonsense. They gave her a predicate notice that said, you may qualify for legal assistance from, various people, but the summons, of course, was a standard 20-day, here's what you got to do. And of course, she didn't read it and she almost got defaulted. And anyway, I tried really hard and then I appealed it. So we'll see what happens.
and so if I'm understanding right, this was the landlord's attempt at an end around
Yeah,
on the
absolutely.
unlawful detainer. And so
Yep.
I'm guessing that this was a city of Tacoma case where they thought, I'm not going to be able to do this because of the various moratoriums and whatnot. But hey, if I go this route, I might be able to get some relief in the summer or the winter or whatever it might be.
Yes, it was a Seattle case actually.
Oh, Seattle
The
case. Okay.
caption is Riviera Northgate Apartments versus Ruby Kane. And it was clearly a residential tenancy. Everything was there to say this is a residential tenancy. And the landlord decided it took too long to get through unlawful detainer commissioner court. And so they just decided that they didn't feel like according her the protections that she has available to her. And Seattle's a little bit fussier than the state, not a lot. And so I really gave up on that argument in my strict reply. I wanted to focus on this person as a residential tenant. 5918, I think it's 430, says that you will apply every part of this
Mm.
statutory plan in dealing with a tenant. and that this particular landlord was like, la la la, I don't have to. And they didn't.
And so their theory was we can serve uh,
Ejectment.
a summons and complaint for ejectment, get them served, perhaps default them. If not default them, bring them in on summary judgment. And this will all
Yep.
be quicker than a King County unlawful detainer.
That was exactly their logic.
Okay.
Yeah, that was just wild. So, and they basically said, well, because we choose to do this as an ejectment means that we don't have to provide her with the protections under the RLTA.
You're right.
Well, that doesn't depend on your choices. That depends on whether, you have standing or whether the defendant has standing as a defendant and unlawful detainer. And the only other thing I would say is that in ejectment, there is no risk of the case being indexed as an unlawful detainer, which means that there's no hit to the tenant's credit. It doesn't say that they've been a
Hmm.
defendant in a ejectment lawsuit. And I think that's because in the case indexing orders at the beginning, where you say what kind of lawsuit you're getting, I know we say it's ejectment. No, it's quiet title, which is frequently between two neighbors trying to
Yeah.
decide where the property line is. So
Hmm.
anyway, that's a little bit of a benefit to these tenants. So
Yeah.
yeah, but it's very much up in the air right now. I just don't know what they're gonna do.
And is the landlord in that case simply arguing and just sort of like a choice of law, election of remedies? Hey, I can go either of these ways.
Basically, they are saying that. And then they cited to this case up in Everett, Housing Authority versus Terry, which is a unlawful detainer that was dismissed based on the landlord not having given a proper predicate notice. And they were saying that Terry stands for the proposition that the choice is up to the landlord what they want to do. No, that's not what it says.
Mm-hmm.
It says you got to give the right notice.
Yeah.
Indeed, you get to choose. In my opinion, was just perfect dicta. So anyway, I'll be quiet. This is you teaching people, not me. So
Well, no, this is interesting stuff, and this level of
yeah,
detail, I think is helpful for all of us.
yeah.
If I may interject, it was put into the Q&A, the Division 1 87561-2 is the case that Attorney Powell is discussing. It's
Excellent.
actually in our chat.
Yeah.
Perfect. Well, hey, we'll all keep our eyes on that. All right, moving on. Well,
Yeah.
okay, so this slide, and I think to some extent we've sort of covered it, but this is just a very, very high level history of the evolution of the statute. And today we've learned that it was codified when Washington was originally a territory and apparently part of the very first revised code of Washington, which, if I remember right, wasn't called the Revised Code of Washington back then.
It
It
was not.
Remington's Code.
Oh no, it was something even before that.
Okay.
So yeah, but it's in my opening brief.
Okay. Um, but what we see here is that it goes far, much further back than the origins of Washington, and it can find its roots all the way back into the 13th century common law in England and courts of equity. And again, it was ultimately codified in Washington state. So this is an interesting caveat. We've talked already this morning about the fundamental purpose of ejectment and quiet title being sort of establishing or declaring who owns something, so clearing up title issues. However, there is case law out there that allows you to bring such an action even when you are not the fee holder. You may be able to proceed under these theories under a leasehold, a life estate, or some contractual right to possess the property. 728.010 states that all that is required is a valid subsisting interest in real property and a right to the possession thereof. Now, that provision may be somewhat limited in the big picture, but it is important to understand that this isn't just simply limited to two folks fighting about who should be the title holder, or where the property line should be. There may be other applications here. But again, whether you're bringing it under the theory of title or some contractual or leasehold or estate-based theory, the objective here is clarifying what those rights are. It is not, as we've talked about under the 9A 56 provisions, or under the unlawful detainer type actions. It's not merely possession. It is some declaration clarifying what someone's rights are. And again, these actions are also often brought either in conjunctions with a request for declaratory relief, or sort of as a theory supporting declaratory relief, because at the end of the day, conceptually, they very much overlap. A quiet title action, while sort of authorized under a different statute, is in form very much a declaratory action. Certainly declaratory actions can touch a whole bunch of things that a quiet title action can't, but the kind of the underlying idea or the concept or purpose is the same, and that is, we need the court to tell us who owns this and where the property line is and whether or not that deed from 1922 was valid or not, things of that nature. Getting into quiet title more specifically, these are equitable proceedings, and as we've been discussing, they're fundamentally authorized and intended to remove cloud on title or settle disputes about ownership or ownership interests. You do not need to be in possession of real property. Again, it is title that is at dispute here, not necessarily possession. The burden of proof under Washington case law is that you have to prove that you have superior title, you have the subsisting interest, you have a right of possession if that's what's being asked for. The distinction here is that it is not going to be sufficient to prove that your defendant doesn't have title. The plaintiff's burden of proof here is to prove superior title. And it is relief that is declaratory in nature. It will result in a judgment that declares the state of the title against the world, and it may be enforced later against unknown parties or parties who weren't pled into this case. But it is a way of resolving clouds, issues, disputes, things that have happened previously, and have a fresh starting place to move on from. Any thoughts from anyone out there that might help us expand on this, the other uses of quiet title? All right, let's go move on then. There are some very important procedural distinctions here in quiet title versus ejectment. So ejectment provides for jury trial. It is an action at law, I guess, in this regard. Statutorily, it specifically provides that ejectment actions are authorized to be tried in front of a jury, and that's 728(1)40. Historically, quiet title is an equitable action, and equitable actions or actions in equity are typically tried to the bench. However, it gets a little more convoluted here. The statute 728(1)40 is a bit vague. And there is argument out there that quiet title might be tried to a jury in and of itself. Although I think that the way that that is more typically resolved is commonly a quiet title action is going to be brought with some other legal action, whether that is an action for declaratory relief, an action for ejectment, an action for adverse possession, an action for trespass. Any number of other actions are likely to be pled along with quiet title. And so in those circumstances, it's ultimately going to be up to your trial judge to decide whether or not the case would be bifurcated, or make some other provisions on how you're going to deal with the legal versus the equitable actions within any given case. And the case law that I've looked at in this regard does indicate it very much is a case-by-case basis. There is not a bright line necessarily that a court is going to employ when making these decisions about how you're actually going to put these cases in front of either a jury or to the bench. That decision is going to be made based on the specific facts, needs, and what's at stake in any given action. Does anybody have any experience in this bifurcation issue? Anybody ever put this to a judge and said, hey, how you want to sort this out?